Don't do what my granddaddy taught me to do.
Don't forget what we did today. Today is history.
As a black man, I stand up for black women.
Why is everybody, why is the police fighting against us, but they're supposed to be helping us? That doesn't make sense.
Live it!
Hi, I'm Judge Julie Kaelin. I'm a district court judge here in Louisville. I'm here with Maxwell today in court. We are holding criminal court today. And one of the things that I think is important is that I think that the court should work for the people, not the other way around. Very often I see that the courts do things because they're convenient for the courts, but that's not really the best thing for the people. I think courts should be open. In today's day and age, news is changing, how people get their news is changing, and the fact that we can live stream is, to me, a really great tool for showing the public what really happens in court beyond the sensational headlines you might see. We're doing real work here every day, and I think it's very important for the public to be able to see what we're doing, and live streaming is one way that allows us to do that. I do live stream every day. I'm the only judge in Kentucky that does that. We have a Kentucky Courts YouTube channel. That is where my stream goes through, and you can find all the videos there. Good morning. Would you like me to move you into a waiting room with your client?
Yes, please, Your Honor.
Just added you, I'm sorry.
No, you're good. I'm still looking at my case, trying to come up with an offer as well. So.
Okay, so you want me to put you in a room with your client?
Yes, please. May I approach?
Sure.
Can I bring legal with me? Person with me?
Yes. Hi. I love meeting new people. Hi, I'm Judge Kaelin. Good to meet you, Marina.
She used to be PD.
You have an excellent person to follow today. Yeah, I was in PD for almost 5 years. Like, if it wasn't for my parents who paid my loans for me while I was there, I probably never would have left. I loved it. I hope you love it too. I can help you with it now. Thank you.
Are we using a career?
What's that? Okay, good.
Ibrahim Haji? Belinda Inglewood? Derek Family? Andrew Jones? Michael Lofton. Okay, Mr. Lofton, I'm still waiting for your attorney on the 24th signature.
Phelan?
Mr. Phelan, come on out.
Morning, Mr. Phelan.
Morning.
All right, so Mr. Phelan has 3 cases on my docket today. The first one is 21M326. That was charged in January of 2021. The second one is 21M612. That was also charged in January of 2021. They're about 2 weeks apart. Mr. Phelan ultimately pled guilty to assault 4th degree domestic violence in both of those cases in February of 2021. He was sentenced to 365 days, but did not have to serve that on the condition that he had no offenses, no contact with the witness, and completed certain treatment requirements. Has any VIP been completed? Completed VIP. We are here today because Mr. Phelan has once again been charged with assault and 4th degree domestic violence. All of these cases, I should note, are with the same witness. This assault 4th degree that is the new case that was charged July 27th is a 3rd offense within 5 years. It was amended up to a felony at arraignment. Today, the county is requesting that it be amended back down to a misdemeanor offense of assault 4th degree domestic violence. Do you know if the Commonwealth Attorney's Office reviewed this? And they declined to indict it? Okay. This is a true 3rd, I'll note that. I did not see any priors other than the 2 we've just discussed with regards to any domestic violence offenses. Is that correct?
That's all the time.
All right, Mr. Phelan, the agreement that you've reached calls for a new 365-day sentence. This time, instead of that just being held over your head, it will be monitored by a probation officer. This is misdemeanor intensive probation. It's called intensive probation for a reason. You understand that you will be required to report to a probation officer when they tell you to do so.
Yes, ma'am.
You understand that they can search your home at any time.
Yes, ma'am.
You understand that they may refer you to additional treatment and that you will be required to complete it.
Yes, ma'am.
You understand that if you fail to do any of those things or have contact with the witness in this case, or pick up any new offenses, that you could be ordered to serve this 365 days plus the remaining 185 on your other cases.
Yes, ma'am.
Have you and Mr. Ferris gone over this order of probation?
Yes, ma'am.
Do you understand that a very crucial term of this probation is no contact with Ms. Snap?
Yes, ma'am.
Did you and Mr. Ferris go over this guilty plea form?
Yes, we did, ma'am.
Do you understand that you do not have to accept this agreement? You could demand a trial instead.
Yes, ma'am.
If you had a trial, it would be up to a jury to determine whether or not your guilt had been proven beyond a reasonable doubt. And then you would have additional rights, like the right to question witnesses or the right to appeal if you were found guilty. Do you understand that when you plead guilty, you give up those rights?
Yes, ma'am.
Do you also understand that pleading guilty in this case will extend the amount of time where you're subject to that felony charge for a 3rd of assault 4th degree within 5 years?
Yes, ma'am.
All right. Is there anything that you need more time to discuss with your lawyer?
No, ma'am.
Sir, how do you plead to assault 4th degree domestic violence, guilty or not guilty?
Guilty.
Mr. Phelan, I'm accepting your guilty plea. We're gonna get you a copy of your probation order. As part of this agreement, you are agreeing that you violated the terms of your prior probation and that you will serve 180 days on home incarceration. You've been in the jail for 16 days, so that leaves you then with 164 days on home incarceration. You will have probation, parole release, treatment release, and work release while you are on home incarceration. Do you understand that you are not allowed to ask for early release from that HOP? You're not, you have to do the full 164 days on HOP.
Yes, ma'am.
Okay. Mr. Phelan, I'm gonna enter these orders You should be released to HFQ later today. I want to make something very clear to you, and Mr. Barris can tell you, I'm very serious about domestic violence cases. It's probably the one thing where I just am very, very tough on those cases. If you come back in front of me and there's an allegation that you've had contact with Ms. Snap, or God forbid there be an allegation that there's been new criminal activity against Ms. Snap, I will not hesitate to give you the full 365 days plus 185 days sitting in the jail. Do you understand that?
Yes, ma'am.
I promise you, I will not hesitate to do that, okay?
Yes, ma'am.
That's all for today.
Thank you, Judge.
Are there any victims or witnesses that make off 302 as well? Victims or witnesses?
Number 76, Todd Fowler.
Present, Your Honor. Y'all warned Mr. Fowler's coming up. Good morning.
Good morning. Oh, there. All right, on Mr. Fowler's case today, there is an agreement to set aside the prior guilty plea and dismiss on a stipulation of probable cause as is complied with the terms of the agreement. All right, so dismissed, thank you.
Thank you. God bless you.
And 53, Tyree Harvey.
Case number one for Mr. Harvey. Judge, he's in custody in Clark County.
Oh, okay. So we just need your authority to work this out?
Yes, and we're not OPAing him because it's a credit time serve offer. I don't think we need it.
Yeah, that sounds great. Okay, October 18th, thank you.
Thank you.
And the other cases you want?
Yes.
Nathan Edgerton.
Mr. Streetby on John Harr, number 5455.
I asked that I not put a date that we need guidance from the court.
Just a span.
Okay, I saw the motion continue to get evaluated, but are you requesting a warrant today?
Well, so Mr. Streetby and I spoke this morning, and it's his understanding that Mr. Harr is in Illinois. and now he's just working with him and maybe he's in hearing and this is an out of custody, evaluation, for which someone has been to appear a couple of times. If he's in town, I think maybe it's possible we could expect to get it set up and maybe follow through. I don't.
It's just a whole too.
I know, and there's been a lot of insurance, you picked up in multiple counties.
Yeah, it seems like that's what happens, is every time he's here, he gets released and then doesn't come back and then gets picked up somewhere else.
Correct. So, I guess,
That'll be hard, I mean, he's been all over.
I'd like to respond. I filed a motion for both competency and responsibility. Because early on, I was advised by his mother that he suffered from bipolar and the Alzheimer's and he is on disability. Because of that background, I requested and motion for his evaluation, which he, I think, 2 or 3 occasions still here. His mother has been, or was, his one anchor in life. She died of cancer about a year ago.
I'm sorry to hear that.
And his stepfather, who he had a, tumultuous relationship with, left. So he basically left him alone. He then moved in with his grandmother, who was elderly, and she tried her best to help care of him. She's moving out of state. So he was with a cousin in Illinois. He called me yesterday, and I suggested if he's available by phone, maybe we could keep up that way. But then he called me maybe 15 minutes ago to tell me that he's back here in Jefferson County.
But not here in court.
Not here in court, right. I kind of regret that I filed a motion because over the past several months of my dealings with him, I know he's rather bizarre behavior. He does suffer from bipolar. I don't believe that his mental illness is sufficient either to justify a responsibility finding or a defense. I just think he's rather bizarre. These events he's charged with, one is an assault with his stepfather. The stepfather has left for parts unknown. And I'm hoping that if he were here and was confident that to negotiate a plea that we could resolve. And I can't retract what motion I filed. I wish I could, but I can't. I'm asking for a begging for giving
What about competency being fluid? Can you all not hurt hers?
I think that once the motion is made, I think an evaluation has to be made, especially given the fact that Mr. Sheedy hasn't had any kind of regular
That's true,
contact
that's
with
true, that's true, but I'm thinking like, what about a case where, it's filed and 20 years later, the person's obviously fine?
Right. But I think in this situation.
Yeah, that's not that.
Right.
Okay, so what are the proposals? I guess you're asking to continue, what does the county want to do?
I guess if he's in Kentucky and there's actually good contact, I'd be willing to pass once on a motion bench warrant.
Maybe we can try to come back fast, so if you reach them, it's like right around the corner. What do you think about that?
I don't think he's, well, I'm not sure.
We can put it on for, tomorrow, we can put it on for Monday, we can put it on any day next week, probably.
You want to try to put it on tomorrow and see if we can get him here, and then we can try to get an evaluation scheduled?
I'd rather do it Monday, but that's fine.
That's fine, that's fine.
Monday's fine, Monday, August 15th. And they're doing a lot of these evaluations electronically now, where they can, this looks like maybe one really good, so, hopefully if you can get this tacked down and get something done. Okay, thank you all.
Thanks, Rich.
I could briefly approach about something.
Sure.
I've never done this before, so I want to correctly. I can't answer for
what we need to do is have the summons served. Is your client's other case on today, or can you have to leave and say that? Yeah. So what I would prefer to do, this will be up to you, Mr. Bailey. Okay. My preference would be to serve the summons on him today on this, and have the clerks notice it for court Monday. Okay. Tell your client he doesn't need to be here, he's gonna be dismissed merged that day. But that way the clerks don't have to stop what they're doing, not even these particular clerks, but even in the older clerks. Then they don't have to, in the middle of the day, make a new case, blah, 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 get it to the courtroom. Understood. You see what I'm saying? That makes sense. So what I would like to do is serve your client and that's what I would like to do. Okay. And is your client in the courtroom?
She is out in the, she's out in the hallway.
Okay, so make sure this is okay with Mr. Bailey. Okay. And I will go ahead and put this into convert to summons. Okay. And then when you all come back in to have the case called, we can get her served with the citation. Okay, that would just make sure she knows, like, you're gonna go in jail, you're going to wear this, gonna give you the citation.
That's what I was trying to do today. I just wanted to make sure I never really had this happen. So
now you have.
Every single day here.
Thank you.
Thanks, Judge.
Ms. Greenwell, for some reason that did not pop right. Oh, hang on a second. Maybe I've got it. Yep, I've got it.
Got it. All right. Thank you so much. I will be back. Sorry.
Yes.
Patrick dropped out of Zoom while we were in the middle of the.
Oh, somebody's calling in. I bet that's him.
I think she's, I saw her pop back.
Hi, this is Judge Kaelin who's calling in.
This is Lashana Harker. I was on Zoom and it's trying to die down here. I was talking to my public defender and it's cut way off.
All right, I'm gonna, Miss Christian's standing here with me. I'm gonna move you back to the room with her.
Okay, thank you.
Hi, I'm Judge Julie Kaelin. I'm a district court judge here in Louisville. I'm here with Maxwell today in court. We are holding criminal court today. And one of the things that I think is important is that I think that the court should work for the people, not the other way around. Very often I see that the courts do things because they're convenient for the courts, but that's not really the best thing for the people. I think courts should be open. In today's day and age, news is changing, how people get their news is changing, and the fact that we can live stream is, to me, a really great tool for showing the public what really happens in court beyond the sensational headlines you might see. We're doing real work here every day, and I think it's very important for the public to be able to see what we're doing, and live streaming is one way that allows us to do that. I do live stream every day. I'm the only judge in Kentucky that does that. We have a Kentucky Courts YouTube channel. That is where my stream goes through, and you can find all the videos there.
On forum.
Thank you, Your Honor. Oh, very, very, Mr. Fong. He's present in custody.
Are these the only cases holding?
Yes.
Hey, Mr. Foreman, right down. All right, thank you for asking. Mr. Foreman, it looks to me like you and Mr. Carter discussed this and you've reached an agreement. You have 1, 2, 3, 4, 5 cases on the docket today. However, 3 of those cases, all charges are being dismissed. Those are all traffic charges that are being dismissed because you worked out an agreement on the other 2. On the most recent case where you had traffic charges including expired claims, driving without insurance, and operating on a suspended license, the agreement is that you will plead guilty to no insurance and operating on a suspended license. For the suspended license charge, the agreement is a $50 fine and court costs. We'll talk more about whether or not you have to pay any of that in just a moment. With regards to the driving without insurance, on that charge, there would be a penalty of a $1,000 fine. You would not have to pay that fine though, at least you would not have to pay $900 of it, so long as for the next 2 years you have no new offenses. That would leave you owing $100 in fines, in court costs of $145 on that case, but like I said, we'll talk more about that in a moment, determine what you will actually have to pay. Then the other case is a case from February where you were charged with multiple possession charges as well as driving without insurance. In that case, the agreement is to dismiss all charges except the possession of heroin. That charge would be amended to the misdemeanor offense of attempted possession of heroin. The agreement in that case is for a 365-day sentence, but again, you do not have to serve that so long as you have no new offenses. And then in this case, you are also required to enroll in drug treatment and bring back proof. You understand that that is a crucial part of that agreement, that you must bring back proof in order to avoid serving any jail time. All right. Now, it looks like the agreement on that case is to go out to October 18th. You are agreeing that if you do not bring proof that you have enrolled in treatment or get that to your attorney before then, that you will be subject to 10 days in jail. Do you understand that?
Yes, ma'am.
All right. That is the heroin rocket docket deal, I assume?
Yes.
Okay. And Mr. Forum, that leaves you pleading guilty, once all is said and done, to the attempted possession of heroin, driving without insurance, and operating on a suspended license. With regards to driving without insurance, that's what we call in Kentucky an enhanceable offense. What that means is if you were to be charged with no insurance again, the penalty could go up because of having already pled guilty today to one offense in that. Do you understand that?
I understand that.
Did you and Mr. Curry talk about the fact that you have the right to demand a trial instead of pleading guilty?
Yes.
And do you understand that if you plead guilty to these charges, you give up your right to have a trial on them and admit that you are in fact guilty?
Yes, ma'am.
All right, sir. The only other thing I need to ask you is how do you plead to attempted possession of heroin, no insurance first offense, and operating on a suspended license? Guilty or not guilty?
Guilty, ma'am.
Mr. Curry was talking about the court costs and fines. Is he unable to pay or?
He's had some economic downturn, and of course he will be. He has worked out that he's going to be in a residential rehab.
Oh, I'm gonna put some delivery.
Thank you.
I don't want you to be worried about paying this if you're gonna go in the inpatient chamber, okay?
Appreciate that, ma'am.
All right. Anything else for today?
I believe that does it. Well, if he has no holds, he should be released.
I'll enter releases on all of these cases. And, Mr. Forum, we are gonna have a document for you called an order of conditional discharge. It just puts into writing that you have this time over your head. We'll send that back with you, and I think that's it.
Thank you very much,
Okay,
ma'am.
y'all.
Okay.
She's in touch with my mom. It's just, thank you, Rob.
Thank you all.
number 31, Karen George.
Set the one for George, Judge, he's coming up. Come on, just come on,
Hi, Mr. George. Thank you for asking. Sir, I understand you've reached an agreement in this case where the charge would be amended to disorderly conduct in the second degree and the penalty would be 1 day to serve, which you've already served. Is that your understanding of what you were agreeing to today? Did you and your attorney talk about the fact that you do not have to accept this agreement? You could be made a trial instead. When you plead guilty, you're telling the court you do not wish to have a trial and that you admit you're guilty in this case of disorderly conduct. Is that correct? And you still wish to plead guilty? On accepting your guilty plea, the court cost will be credits unserved. Anything else?
No, Judge.
Have a good day.
Thank you.
Number 11, Justice Inky. County is requesting a bench warrant. He is not present. He has not been present in any minutes. So through this. In 2020, he was not present. Then he was and pled guilty. Then he was not present in October. He was arrested on that. A warrant was issued by another judge in October. He was arrested on that warrant last week. Warrant served, bond posted in on in Rowan County, $100 cash, and is not here now. Look at the paperwork about now. Next court date, court will notify. That's what it says. It does not say the court is today. Anywhere that I can see. So I'm gonna decline to issue a warrant. See what is, if it is a new address on the bottom paperwork. Court notice. But it's really what we told them we do. On this case where I'm sending court notice to this defendant's new address, I'm gonna write on here, please send Zoom info. If their court notice doesn't have the Zoom info, does it?
I'll make sure it's on there.
Okay, thank you so much. The prosecutor wrote that up. Is there officials on it?
Eric Hemerling. Eric Hemerling.
Hey, Mr. Lynn, it's Judge Kaelin. You don't need to call me back. I just wanted to let you know on number 11, Justice Inky, it came in with a request for a bench warrant and a note that a warrant had been served in Rowan County, and that he was given the date. However, if you actually look at the bond paperwork he was given, it says court will notify. It was not, as far as I can tell, this person was not actually told what their court date would be.
So I'm not gonna issue a warrant under the court notice for September 6th, just wanted to let you know things. Number 75, Nathan Endrington. Present, was an active warrant for Orlando.
Dawn Collins here.
59/61, Demetri and Herbert.
One judge cares who heard it since they forward.
All right, so Mr. Herbert, I've got 3 cases here in front of me. One of them is a case where you were charged with enhanced possession of marijuana and some traffic offenses. All of those charges are being dismissed on an agreement to forfeit the block and magazine that were seized at the time you were charged in that case. Is that your understanding?
Yes.
All right, sign that forfeiture order. On the next case, this is a case from 2020 where you previously pled guilty and agreed not to have any new offenses. That was in regards to, is that domestic? I can't tell.
I believe so.
Duplicate files. All right, so in that case, you had pled guilty and agreed not to pick up any new charges. Of course, one of the things we are here for is that you have picked up a new charge, a new case with domestic violence charges of strangulation first degree and assault fourth degree. The strangulation is being dismissed, but you're agreeing to plead guilty to assault fourth degree domestic violence. The sentence there would be 365 days. Rather than that just being held over your head, that would be a misdemeanor intensive probation, meaning you will have a probation officer. Do you understand that you will have to report to your probation officer as they tell you to? You understand they can search your home at any time. You understand that while on probation, you will be required to complete the matters intervention program and to have no contact with the witness until further order of the court. Do you also understand that you will have, you are agreeing to have no new offenses, just like with your old case?
Yes, ma'am.
With that old case, because you have picked up a new offense, you're agreeing to some home incarceration time as a penalty for that. It looks like you would have 21 days remaining out of 36 total days on home incarceration. You will have job search work release and probation and parole release. Do you understand that as well?
Yes, ma'am.
Alright, sir, have you and your attorney talked about the fact that if you plead guilty to assault fourth degree domestic violence, that charge will be on your record? If you're charged with a third offense within 5 years, even if the injury is only a misdemeanor level injury, that can be charged as a felony because it would be a third offense within 5 years. Did you and your attorney go over this guilty plea form?
Yes, ma'am.
Do you understand that you do not have to plead guilty? You have the right to demand a jury trial instead.
Yes, ma'am.
When you plead guilty, you're telling the court, hey, I don't want to have a trial, I admit I'm guilty. That means you give up the rights that would kick in if you had a trial. Is that what you understand as well?
Yes, ma'am.
And how do you plead to assault fourth degree domestic violence, guilty or not guilty?
Guilty.
I'm accepting your guilty plea. You're gonna get a copy of your probation order. You're gonna have to report to probation and parole and get signed up. They will assign a probation officer to you. They will get you started at your classes. You will continue to be on home incarceration for another 21 days.
Judge, I do think that might be an error. I don't think he'll be on parole. He should be off by August 19th. That was part of the
It says 36 days to serve 15 credit.
I can go through that page. Part of it is he'd be off by the 19th.
All right, I'll hold this to the side.
Thank you, Judge.
Just have a seat, sir.
Have a seat for that.
You guys remember the brothers?
Yes.
discovery, I'm gonna tender it just a month before.
No.
And,
Okay.
fair enough.
I trust that your ability to communicate that amongst yourselves.
Thank you. Good day.
Number 63, maybe 64, Franklin Herrera Rodriguez.
63 on the morning.
Oh, okay, 63 and 63. Hi. All right, so on the morning docket case, hello, sir. There is an agreement that the enhanced trafficking in marijuana would be amended to misdemeanor trafficking in marijuana, is that correct?
Yes, ma'am.
The same rate is so great. All of the other charges are dismissed as merged, and this is a 60-day sentence conditionally discharged to you, is that right? Okay. All right, so sir, it looks to me like the agreement you've reached is that you would plead guilty to misdemeanor trafficking in marijuana. There would be a 60-day sentence. You do not have to serve that so long as for the next 2 years you do not have any offenses and you do not possess any guns. If you abide by that for the next 2 years, then this guilty plea can be set aside as though you never pled guilty 2 years from now. That would allow you to have the charge dismissed and get it expunged as well. Is that your understanding of what you were agreeing to?
Yes.
There is another case that is on our afternoon docket today. That is just traffic charges. I truly have no clue.
Dismiss merge.
All charges dismissed merge, okay, thank
And I
you.
believe we had talked about an August 9th, 2024 date for the set aside, but I don't think you wrote that on there.
That's fine, I'm happy to put that date in. Okay. Okay. Mr. Herrera Rodriguez, is everything that I just said your understanding of what you were agreeing to as well?
Yes.
All right. Have you and your attorney talked about the fact that you could go to trial instead of pleading guilty if you wish to do so?
Yes.
When you plead guilty, you're telling the court you do not want to have a trial and you admit you're guilty. Is that correct?
Yes.
Did the two of you go over this guilty plea form?
Yes.
Is there anything that you would like more time to discuss with your lawyer before we move forward?
No.
All right, have you plead to trafficking in marijuana under 8 ounces, guilty or not guilty?
Guilty.
And Mr. Butler, it appears part of this agreement is also forfeiture of the weapon that was seized at the time that your client was charged, is that correct?
Yes, ma'am.
I will sign that forfeiture order, and make sure I get this passed in here.
It was a Friday, August 9th, 2024.
Thanks. I'll be not here, it's 55th wedding anniversary.
Oh, wow.
All right, so we will set that for review. Mr. Herrera does not need to be here. The next person's waived. All right, and let's talk about courthouse. Was he in custody at all? All right, so sorry. Thank you. All right, so we're gonna have some paperwork for you. It's called an order of conditional discharge. It just puts into writing that the 60 days is over your head for 2 years. If you have a seat back in the audience, we'll call you up when your paperwork is ready and then you'll be good to go. Okay? Thank you all. Number 5, Sean Dabney. Hang on a second, is Mr. Harris back there? Okay, we'll just wait for him to come back. Okay, thanks. Right, David Hacker, these are Miss Mahan's cases. Mr. Hacker is in custody in LaRue County and was not brought to our Zoom today, although we did do an OPA previously. It looks like she's requesting to simply pass these to October 18th to get the new OPA. I'm going to put in her Zoom info. You all do not have a David Hacker in the background. Alright, so those are all my letters and dates. Mr. Harrison, admin number 5.
Joseph Paul.
Alright, we're just passing this to review some status of another case. That's all for you, Mr. Hacker. I'm not, I think it's so review for that too, sorry. Okay, great. Mr. Hubert, you want to? 28 days. All right, so it's incorrect. You're like 28 days credit, so you will have 8 more days on home incarceration. 8 more. 8 more. Dismissal, we've got the new case. Alright. Mr. Herbert, I'm not exactly sure where we left off. Did I talk to you about if we thought I could stop them on here? I think we went through all of that. Did I take a guilty plea? All right, we'll get that changed. Thank you all, and Mr. Herbert, we're gonna have some paperwork for you. Just have a seat with my contract. Number 57, Lashana Hatcher.
Ms. Hatcher, she is on Zoom. We resolved this.
Ms. Hatcher, it's Judge Kaelin again. Can you hear me?
Yes, ma'am.
Now, I understand that you and Ms. Christian have had a chance to discuss this, and you've reached an agreement in this case where the paraphernalia charge would be dismissed and the felony possession would be amended to the misdemeanor offense of attempted possession of a controlled substance first degree. The sentence would be 270 days. However, you do not have to serve that 270 days so long as you do not have any new offenses for the next 2 years. Is that your understanding of what you were agreeing to? talk about this such that you understand your options, your right to go to trial, and your right to go along with having a trial?
Yes, ma'am.
And do you understand that if you plead guilty, you give up your right to have a trial?
Yes, ma'am.
All right, how do you plead to attempted possession of a controlled substance first degree? Guilty or not guilty?
Guilty.
I am accepting your guilty plea, Ms. Hatcher. I have a Phillips Drive address for you. Is that still good for us to send your paperwork?
No, ma'am. I actually moved out of state.
Go ahead with your address.
Tennessee.
All right, what's the zip code there in Memphis?
It's 38127.
All right, we'll get your paperwork sent out to you. It's just gonna be called an order of conditional discharge. All it does is put into writing that this 270 days is being held over your head for 2 years on the condition of no new criminal offenses. Ms. Christian, is there anything else for today? All right, Ms. Hatcher, you're gonna hang up.
I'm sorry, there is.
Oh, hang on.
Her mom posted a bond, you need to make sure that gets released.
Okay, I'll make sure that the bond shows is released, and, all right, Ms. Hatcher, you're free to hang up now.
All right, you have a good day. Thank you.
Number 50, Ronisha Hankerson.
Good morning, Your Honor. Brittany Greenwell on behalf of Ms. Hankerson. Ms. Hankerson is present. She's a vote chief. Hi, Ms. Hankerson. Hello.
All right, ma'am, you were originally charged with harassment and theft on taking. I don't think I've ever seen a case coded as personality first.
And it's first for me as well, Your Honor.
All right, so Ms. Hankerson, my understanding is that the agreement you have reached is that you would actually, that theft charge would be dismissed. You would plead guilty to assault instead of harassment, and the sentence would be 180 days. You don't have to serve that 180 days so long as you do not have any contact with Ms. Chin and do not have any new offenses. Is that your understanding of the agreement? Now, there is also, as a part of this agreement, this is very important, that 180 days will be held over your head for 2 years, except if you're doing well, you haven't had any new offenses, and you haven't had any contact with Ms. Chin, then 1 year from now, your attorney can ask to set aside the plea. It will be like you never pled guilty today, the charge will be dismissed, that allows you to get it expunged much more quickly. I will actually set a court date for 1 year from today, so it's there on the docket, it doesn't get forgotten just in case. Is that your understanding of what you're agreeing to? And then we have this, this is when we have this, right?
Correct.
So we have a separate case where you were charged with assault fourth degree. Actually, are these the same person?
Yes.
Okay, I wanted to make sure I was saying the right name when I was telling you no contact with Ms. Chen. So we're gonna serve this summons on you, we're gonna set it for Monday. You do not need to be here Monday, but part of your agreement here is that that case will be dismissed. So we need to, we're gonna hand you a citation, it's gonna have Monday's court date on it, but you don't really need to be here. Ms. Greenwell will be here, it'll only be on the docket for dismissing that case, okay? So did everything that I just say line up with what you thought we were doing today? Okay. Have you and Ms. Greenwell talked about the fact that you could go to trial instead of pleading guilty if you wish to do so? When you plead guilty, you are giving up that right to have a trial and admitting you are guilty, in this case of assault fourth degree. Do you understand that? Now, the goal here with this assault case is that we will set it for 1 year from now, and the goal is you will not have had any new offenses, and you will not have any contact with Ms. Chen, and it can just be dismissed on that day. However, if for some reason that doesn't happen, do you understand this charge could be on your record for up to 7 years? And if you were to be charged with additional counts of assault fourth degree domestic violence, a third offense within 5 years can be charged as a felony. Do you understand that? All right. Have
have you plead to assault 43 domestic violence, guilty or not guilty? Accepting your guilty plea, we are going to have a document for you called an order of conditional discharge that just puts into writing what we've just talked about. We're going to serve you with the summons for the Monday court date that you do not need to be at. I'm making a note here, the defendant does not need to be present. And then, I think that's it. That's it. All right, thank you all.
Hi, I'm Judge Julie Kaelin. I'm a district court judge here in Louisville. I'm here with Maxwell today in court. We are holding criminal court today. And one of the things that I think is important is that I think that the court should work for the people, not the other way around. Very often I see that the courts do things because they're convenient for the courts, but that's not really the best thing for the people. I think courts should be open. In today's day and age, news is changing, how people get their news is changing, and the fact that we can live stream is, to me, a really great tool for showing the public what really happens in court beyond the sensational headlines you might see. We're doing real work here every day, and I think it's very important for the public to be able to see what we're doing, and live streaming is one way that allows us to do that. I do live stream every day. I'm the only judge in Kentucky that does that. We have a Kentucky Courts YouTube channel. That is where my stream goes through, and you can find all the videos there.